as much as we have some very important things to talk about tonight. And I would ask you if it's not at all imperative that you make your public input tonight, and hold it off until next month. But if you feel a need to, please be as brief as possible. I'll start on this side. Anybody have public input? Yes, Marlene?
I wanted to let everyone know that there is a traveling art exhibit that's going to be making its debut in the Middletown Park on May 31st. I have flyers here if anyone's interested. The focus of the art exhibit is based on suicide prevention. I have some flyers here and I'm going to pass them around. If anyone is interested, take one. If not, pass it on for someone else.
Thank you, Marlene.
Okay, thank you. I also have an update on the movie stuff, but that can wait till next month.
Anyone else on this side have public input? You have something to express, please feel free. Anybody on this side have public input? Excellent, thank you. At this time, I'll close public input and bring it back to the board and to the chair. Item 4 is report on the opening of Gibson Library and status of Middletown Square Park, and I'll make that report. We had the opening of the Gibson Museum this weekend. It was delightful, absolutely delightful. And it was just great to see so many people coming. Do we have a chair for Joe? Joe, you get bring a chair. It was a great event, and I'm sorry if you missed it. You missed a great thing. The public, the Middletown Square Park, as you can see out in front, we're going to put down the sod Wednesday to finish the park. During the opening of Gibson Museum, we had a lot of vendors and we had just a ton of people out at the park, and it was everything that we all dreamed of, and that is a beautiful setting and a connection between the museum, the park, senior center, the library, the community center, and it was great. If you didn't make it, I'm sorry. It was worth attending, and we will finish the park on Wednesday or Thursday. Tonight, we have to set a date for the dedication of the park. And I'd like to have your suggestions. If you have a suggestion when we should dedicate the park, I'd like to hear it right now. Hearing no suggestions? I think Middletown Days would be a great time. I don't want to interrupt the thunder of Middletown Days, so I think we'll put it after Middletown Days. I'll talk to Jim Comstock and the county to see when they can do it, because they're a little more, they're not as flexible on their schedule as we are. Okay, that concludes my report. Open discussion on plans for Middletown Days. Any discussion on open, yes, Marlene?
I would like to set a date to clean up the sidewalks and stuff. The suckers from the trees are growing up and weeds need to be pulled and cleaning and that kind of thing. If we could do that before Middletown Days.
The parade is the 22nd, I believe, isn't it?
It's the third weekend.
I think it's the 22nd. Let's make it the week before, Marlene, okay?
Okay, the week before, the Saturday before?
Yeah, the Saturday before we'll have a work day and pull all the weeds and get all the trash up and make sure everything's all stripped up for Middletown Days. You won't be able to be there. I think the week before is better. Okay. 2 weeks before. So let's plan on, what day is that the week before? June what? 16th. We'll do it June 16th. We'll have a Monday. No, not the 16th. I want Saturday. Saturday 14th. So June 14th, we cleanup day for the parade route and downtown Middletown. If you can, please plan to attend. I'll have a trailer there and we'll garbage bags and we'll pick it up and get it out of town. Yes, Marlene?
Do we have a time on that?
Oh, 9 o'clock in the morning.
Okay, thank you.
We'll be buying you coffee at 8:30, 8 o'clock at the Cowpoke in the back. If you're interested in coming, we'll have coffee there and then go out and clean up the street. Okay, Cowpoke at 8:30. Okay. Anything else?
On Saturday after the parade, are you selling any food or anything in the right here?
Yes, I'll get to that. Why don't I just cover it now? We have tried to talk about this park as being part of Central Park, in as much as we don't want to compete with Central Park and their fundraising out there for the kids and all their events. We've asked Central Park to take part in our park and Middletown Days, and whatever we do here, they'll be a part of. Yes, we are going to sell food. Yes, we are going to sell, hopefully, we're going to sell artwork and all of that. And any money that comes from that will be turned over to Central Park. Since MATH has no method to handle any money. We have no bank accounts, we don't have anything, we don't write checks, we don't even touch money. We've been very tough about that. We don't want to be in that business. So we've asked Central Park to help us. I know the senior center is going to have a booth, the charter school is going to have a booth, there's going to be a lot of booths, and there's going to be some food being sold there, and there will be entertainment. We're working with Central Park to get a band that will start playing immediately after the parade. Now, you can ask, why are we doing that? Because every year, for years and years, we have, for example, 1,000 people come to the parade. 3 minutes after the parade is over, 900 people go home and 100 people go to Central Park. We'd like for 800 people to stay downtown and enjoy the park, enjoy all the things that are downtown, and then if they want to go to Central Park, do that. But a lot of people do not want to go out and to Central Park. It's a little dustier than it is here, and there's cowboys out there, and there's horses, and all things go along with horses. So we're trying to get more activity downtown under the auspices of Central Park. So we will have music, we will have food, we will have artwork and all of that being displayed and sold in the park. Does that answer your question? Okay. But it's all under Central Park. Okay?
As a donation, or we're just keeping the money for you? Is that, that's a clarification.
I made that clear to Central Park. They maybe didn't listen, but I made that clear. We have nothing to do with money. Nothing. We don't want any money. We don't want to touch any money. Any of that. We have no method of handling it. So Central Park will get all the money. I want to make, is that clear?
Yeah.
Okay, great. Okay. Item 6. Tabachi-san.
My name's Mike Tabaki, and I guess I'll give you a little background. I'm not going to get into this too much. There's a stretch of road between Putty Creek Road and the cutoff at Harbin Springs Road that has a pavement condition index of 5, which is a failing mark. And last fall, we collected approximately 530 signatures to have that stretch of road repaved. And in February, I submitted copies of the petition to the Director of Public Works, Mr. Scott De Leon, and he provided me a couple of cost estimates. Now, I'll just read a few of the facts on this. It's about 170,000 square feet. Again, the pavement condition index is 5. And he gave me 2 cost estimates of $650,000, and the other was about $412,000. Now, to put that in context, I looked at the county budget, and the revenue that the county receives from the state gas sales tax is approximately $3,718,000. So that's a good chunk of that budget, and I think what I'd like to do is table this until we can talk about it further next month, get into more details.
Are you making a motion to table?
I would like to move that we table this item.
There's been a motion to table this subject until next month. Although, since there's no discussion on the motion to table, all those in favor, signify by saying aye.
Aye.
Opposed? Nay? Any abstentions? Motion's, item 6 has been tabled. Okay, now we've got our stuff out of the way, and we can get on to meet and greet and question 2 district attorney candidates. This is how we're going to do it. We've drawn who's going to speak first and who's going to speak second, and they're going to get 3 minutes to make their opening statement, and then we're going to open the questions to the floor, and the questions are going to be starting on this side, and we're going to go straight back, and then we'll come to this side and the questions on this side. This will not turn into a debate between you, the questioner, and them. That's not what this is about. You're going to ask the question, and we want a question, and they're going to give you an answer. If it's not the answer you like, I'm sorry. But it's the way they're going to answer. And you're not going to stand and say, well, that's not true. I know that's not going to happen, folks. Not in this meeting. Not in this meeting. There'll be none of that. If you know anything about the town hall meeting here, you know that I don't put up with that. These gentlemen have come and they're going to spend their time that they can spend with their family, talking to you, trying to give you the information so you can make the decision whether you want to vote for one or the other. That's the only thing we're doing here. This is not a, no one asked if you had a gun when you came in, and if you said no, they didn't say, okay, we'll give you one. It's not that kind of a deal. So ask your question, they'll give you an answer. Okay? If we have time, we can come back and you can do a follow-up question to the same thing. Each candidate, if it's relevant to them, they will answer the same question. So if you ask a question to Andre, then Don will be able to answer the same question. If it's relevant, if it's something that he has nothing to say, he'll say, I don't have anything to do with that, and I have no answer for that. Okay? Are we all clear? You'll find me very flexible, except when it comes to confrontations. You won't like me at all. Okay? Okay? Great. I'd like to introduce first, who will speak first, Andre Ross, candidate for district attorney for Lake County. Andre?
Thank you, Grady.
You're immediately open the door, he's out. My name is Fletcher.
Ladies and gentlemen, my name is Andre Ross, and I'm running to be your next district attorney. I'm a refugee from San Francisco. I moved here in January of 2007. If you want any biographical information, you can go to my website, www.andremross.com. There is ample information about my educational background, my qualifications, my history, and my vision for Lake County's future. I'm going to get right down to brass tacks. I'm grateful for the Middletown Area Town Hall to bring us in here today. This is our second debate. Last week, Don and I spent a little bit over an hour in the Board of Supervisors chambers talking about what our respective visions are for Lake County. At the very end of that debate, we were each given an opportunity to ask questions of the other candidate. And I posed some questions to Don, which I think are particularly important to your decision as to whether or not you want to re-elect Don Anderson to be your district attorney. Specifically, I asked Don whether he was truthful to you, the voters, in September of 2010 when he told you at another debate hosted by Liz Larson in the Lake County Chamber that he was at no time suspended from the practice of law in September of 2010. I also asked Don Anderson whether he was truthful several weeks later before the election when he told one of his deputy DAs on a radio program that at no time was he suspended from the practice of law. We had a very spirited debate. I have 25 copies of the DVD of that debate, which I will make available to anybody who wants to take one home. If you haven't seen it online, you can take it home and listen to it and make up your own choice. The problem is not whether or not Don Anderson was negligent in letting his bar license lapse for 8 days in September of 2010. Unfortunately, and believe it or not, lawyers are human beings, and they make mistakes all the time. The problem here is that Mr. Anderson allowed his license to lapse and practiced law for 8 days in Lake County in violation of pertinent sections of the Business and Professions Code, which render that a crime. It's a misdemeanor with a 6-month jail penalty and a $1,000 fine attached. Mr. Anderson concealed those facts from the voters in September of 2010, and he obfuscated about the truth. He told stories. And
30 seconds.
if you go to my website, you can see the pertinent timelines that the State Bar enforces upon all of us lawyers with respect to our compliance with MCLE requirements. You can see the court minute orders of Mr. Anderson making daily appearances in a variety of family law matters while he was suspended from the practice of law. And you can see the transcript of Mr. Anderson's debate statements with Mr. Rhodes 4 years ago, and you can see a transcript of Mr. Anderson's statement on the radio. All those documents are readily available to you.
Thank you. Mr. Anderson.
Yes, thank you very much for the opportunity. And welcome to actually probably our last debate, at least our last scheduled debate. And hopefully, I don't want to spend time right now, hopefully somebody's going to ask me a question about what Mr. Ross just addressed. I will explain my position. What has happened in the last 2 months is I've heard a lot of ridicule, a lot of insinuations, not only about me, but about the DA's office. But they're all in generalities, and that's what politicians want you to do. They want you to listen to generalities. They don't want to tell you specifics. Hopefully you have come here today to learn about us. Saying this myself, I want to learn something tonight. And as you pose the questions, I don't, but you do. I want to learn why comments were made by Mr. Ross that he will clean up the problems that he senses exist in the DA's office. My question is, what problems? He has never said anything. He has said my conduct after being elected inspired him to run for the district attorney. He has never told me, or anybody, what conduct is he referring to. I want to hear this, please. He said he had the impression that there was confidential information leaking out of the DA's office, either to the press or to other attorneys. Where does he get this impression? What is the basis for it? What information? What cases? We don't know. We have not heard this. He has said that there are politically motivated cases that have been prosecuted and investigated by my office. This, I think I know a little bit what he's talking about. And I think you probably do too. But my question is, what basis does he have why he thinks these are politically motivated? Because they're not. I don't do any of my decisions based on politics or any personal feelings. Lastly, he said, or he called Lake County criminal justice system dysfunctional. And he said that Lake County is the best little backwater asylum in Northern California. He said that on tape last meeting. I want to know why he thinks that. It's very important to me as a voter, and it should be very important to you as a voter. All my qualifications and what I've done and the comparison is in the pamphlets that have been passed out. Please look at them, and I'm willing to address any issue that you want to bring up, especially the issue that Mr. Ross enters for. Thank you.
Thank you very much. We're going to take 1 minute and we're going to open this up and we'll get some more chairs, okay? Just give us 1 minute. Boy Scouts are now in adjournment, so we can open this wall and slide back.
More room.
Once again, thanks, Doc. One more. Stay where you're All right, great. Thank you very much. Please have a seat now. We have the chair. Call the meeting back to order. Call the meeting back to order. Andre?
You let him borrow his car.
Confirm his card. Okay. No, just give me a minute. Now that we've made opening statements, we're going to have to revise our question sequence here. We'll use that for the first set of questions, this for the second, this for the third, and then we'll double right back and give them another chance to follow up if they want to and if time permits. Thank you, Andre. Okay, questions. Remember, question, we don't want a speech, we want a question for the candidates, and then they will give you their answers, and you'll say thank you very much. Okay, any questions from this side over here? See, no hands. Any questions in this area? Yes, ma'am.
My question is for Don Anderson. Don, you did a radio interview, I think it was mid-March, and at that time you were discussing with Ron Green the Middletown 4 arrest. During that interview, you said that you made the release from jail because you received a call from someone in your office telling you there are innocent people in jail. You don't have to name the person, but who in law enforcement did they talk to?
Actually, I received 2 calls. And to be specific, I was down investigating the family of a homicide case. Receiving the first call from my chief investigator, Craig Woodward, who had told me I need to go back to the office because there are 2 innocent people in jail, so I'm going to have to deal with it. Trying to rush through the interview, I was complete. I got a second call from a deputy DA, Art Grove, who was reviewing the case, and he too said there were innocent people in jail, all kinds of problems, and they're back to the office, and he decided to
Okay, I apologize, ma'am. I meant to say when you stand up, please stand up to ask the question. State your name and your address, if you would, for the record, just so we know who we're. Could you give us your name, please?
Yes, my name is Kathleen Mayer, and I'm a Middletown resident.
Thank you very much. Any other questions? Yes, ma'am.
Mr. Edison, I'm reading your campaign brochure, and I have a...
Your name,
John
ma'am.
Moss. And I have a couple questions about what you're saying, that you increase the integrity of cases going to trial. I'd like to know how that can be measured, and what you use to measure that, and how you've increased the integrity of which cases. Thank you.
The integrity of cases is, especially, it's an opinion. It's not only my opinion, it's an opinion, I think, of everybody in my office and generally of the public. We do not have cases, questionable cases going to trial now like there was before. For instance, the Dinius case, which everybody knows all about the Dinius case, and it was very, the integrity was not there. We don't have those cases. There was a Ronaldo Hughes case, several other cases. And a lot of that is exemplified by what also you read there is the conviction rate. They had a 58% conviction rate on an average for the 2 years prior to my time coming into the office. Now we have an 85% in 2013. 2014, we're only 4 months into it, we have over a 90% conviction rate coming back by juries or judges. And that's what I mean, the integrity of the cases, we're not losing, or very seldom do we lose.
Under, do you want to respond to that?
I think that Mr. Anderson has painted only a partial picture of the successes that his able deputies have had in the recent years. I believe Mr. Anderson has the benefit of a fine group of young deputy DAs that was assembled by his predecessor. What we don't hear from Mr. Anderson is how many cases are getting dismissed, whether or not more cases are coming in, and we aren't getting any guidance from Mr. Anderson as to whether or not there's a training problem or some other cause that might result in better cases coming to the district attorney's office desk. I would presume that the cases that are landing on Mr. Anderson's desk are better quality by virtue of the hard work of our various law enforcement agencies. We're only really getting a partial picture from Don. I think he's got the benefit of a very capable team of deputy DAs, but I think he could do a much better job in communicating with the voters what he thinks he's doing right and why he thinks it's working well. I'd be very interested in hearing him explain.
Thank you. Yes, ma'am. Name? Yes, please.
My name is Wanda Harris, and I am managing Sheriff Rivero's campaign, and I'm happy to be here. My question also is for Don Anderson. It's a three-pronged question, but it's very quick. You can to answer. I wanted to know how many names were on the Brady list when you took office.
Can't give you an exact number, but I believe it was close to 12.
And how many have you removed from the Brady list?
I have to explain that a little bit more detail, just for clarifications. Everybody talks about a Brady list, but there's actually two. There's the Brady list of officers who have credibility issues, and there's what they call the Brady tickler list, which hasn't been discussed very much. Now, the Brady tickler list is part of the external policy. And that is, if we think an officer has credibility issues, but we do not have any documents to support it. If you're on the Brady tickler list, we file what is called a pitches motion. And that is what the law enforcement agency or the county or the city brings in the personnel file to the judge. And the judge reviews it to determine whether there's an issue with credibility. Now, fortunately or unfortunately, however you want to look at it, in the personnel files, everything is purged every 5 to 6 years. So there could be officers who are on our tickler list who might have Brady issues in the past in the file, but will no longer have it because it has to be destroyed. Now, I have taken some of these officers to the tickler list, but they're no longer officers. And some of these officers were, gone 15, 20 years ago. There were a couple of officers I totally removed from the list because, like I did with Sheriff Rivero, I gave them an opportunity to come in and talk to me and explain their situation. And I did not think it amounted to actually being on the Brady list or Brady tickler list. And after reviewing the files, reviewing what we had, I didn't think it was warranted, so I took them off the list. Because unfortunately, the prior DA did not have a concept of Brady, but there was no policy and procedure manual. There was no Brady policy, internal or external. That's one of the things I drafted when I got in. And I'm not going to keep someone on the list when they don't need to or it's not justified to keep them.
And how many are still on the Brady list?
On the Brady list, right now there are 3. 2 of them will be under review as soon as these officers or past officers want to come in and talk to me.
Thank you. Questions? Back here, any questions? On this side? Yes, sir.
I as well have a three-part question. One, where do you get your data flash? You stated that all the people hired were from Don's predecessor. Where do you get that information from? That's to you, Mr. Mills.
I understand. John Hopkins. And I know you're not part of that because you're one of Donnie's hires. But I'm not including you. I don't know how many other deputy DAs have been hired.
Earlier you mentioned law enforcement. Can you please, and this is actually this is part
Dave,
of the
can you stand
three-part.
up, please?
Could you stand up and again?
This is to both candidates. Can you please describe your top 5 most important contributions to law enforcement in the county? Either one for you.
Andre first, because you asked him.
I think the number 5 is kind of arbitrary. I think my top contribution to law enforcement is deciding that the voters of Lake County deserve a choice for who their next district attorney is going to be. And I've set my career aside in order to step up to the plate because we don't have ambitious deputy DAs in the office right now who are willing to challenge their boss. And we don't have people coming from other jurisdictions who are willing to challenge Mr. Anderson. If you look at Sonoma County, you see Jill Ravitch has a deputy DA who's challenging her for the DA seat. And if you look over in Humboldt County, you'll see there are 4 candidates for district attorney there. I think having an honest, competent, credible DA is the greatest contribution a person could make to improving the functionality of law enforcement in Lake County and the amount of justice in Lake County. And I think that that's plenty for right now.
To be clear, John Hopkins did not hire the remaining officers in the department. I've hired 2, only 2 openings, which I might add, one is Danny, the other one's Dana DeVittori, and they have not lost a case since. I congratulate them for that. I think, and I'm only guessing, I'm thinking John Hopkins probably hired 3, maybe 4 of the attorneys. Gary Locke probably hired a few of the attorneys. Prior to him, I think it was Steve Hestrom. Susan's been there about the longest I can think of, and I don't even want to go back that far. Well, she was hired very young. Response to Andre, not too much response to your question. Response to Andre is the reason why maybe someone is not running against me in my office or somebody else, because we're doing a good job and everybody's happy and satisfied and we're making good results. Top 5 contributions to law enforcement. One, I spent 15 years in the sheriff's office. There were hundreds of cases. Contribution, I would say, my 2 top cases, I arrested 2 people who were on a crime spree, several murders, robberies, different things that was done on Kelseyville by Kelsey Law Records. Another one was the shooting death of Sergeant Richard Helbush. I ended up fortunate enough to be able to capture the 2, got in a shootout with them, got a little nick in my leg from a bullet. And maybe a contribution to that is I wrote a book after that. It took me a long time to write this book. And it doesn't deal so much with the events that happen, but it deals with the effects it has on police officers. And I've given this book to several other officers who've been involved in critical instances, not only in Lake County, but throughout the state. I've been asked for this. And that, I believe, is a contribution. I was president of DSA for 5 years. That would be a contribution. To law enforcement, as a DA, I'm always available. I'll get called out all the time for homicide cases, for search warrants. I will give law enforcement advice, help them as much as I can. And maybe the 5th one would be my involvement in the critical incident protocol. And the critical incident protocol is when an officer is involved in a shooting, in a death, or something very serious such as that, I drafted the current critical incident protocol for Lake County, which almost every agency has adopted, which in essence the district attorney's office on these cases will come out and do the investigation, take over the investigation, write a report and determine whether or not it's justified or not justified, or whether or not crime or criminal charges should be placed against either the officer or someone else involved.
You have the third part.
Well, the third part is, so, other than running Mr. Ross, you have not contributed anything to law enforcement in Lake County? Is that what you were saying?
That's not
It's
what
not a
I said.
requirement.
Who said that?
Not me.
I said that making the decision to run for district attorney, given what I've observed in Mr. Anderson's credibility and truthfulness 4 years ago, is my largest contribution to law enforcement. I'm a civil lawyer, I'm a private citizen, and I'm a law-abiding citizen, and I don't believe you have to be part of law enforcement in order to be a capable district attorney. What you need is intelligence, competence, a commitment to upholding the law, and serving justice in every action and every decision you make.
So your answer is no.
My answer is Mr. Anderson, you have, you want to answer that?
No, I think it just pertained to Mr. Ross and
Okay, great. Yes, ma'am.
Hi, my name is Anne Marie. I'm a resident of Cobb Mountain. And my question is for both candidates. I've heard a lot of things, but not a lot about platform. I am interested in what your stance is on juvenile, I would say crime, how it's dispensed. I know it's a very broad question. Let's see. Is your focus towards punishment, rehabilitation? Is it towards diversion?
I guess I can go first.
Okay.
And luckily, if I don't answer the question correctly, our juvenile prosecutor is here, Susan, and she'd be more than willing to talk to you afterwards. But what we have one attorney who is assigned to juvenile. When she's on vacation or something, we have another attorney who can fill in. All of the criminal justice system is focused to rehabilitation, especially of juveniles. But it's a case by case. Certain juvenile cases, you cannot rehabilitate or they're not, well, I say they can't rehabilitate them, but they're not subject to rehabilitation at that time. So we are looking for incarceration. If you start talking about cases of homicides, rapes, robberies, it would be wonderful to rehabilitate, but we have to get them incarcerated to do that. We're not going to allow these people to be taken home by their parents and go through counseling sessions. So it's an individual case-by-case basis. But just juveniles, to me, are kind of just like adults. If you can rehabilitate them, fine. That's why I have the diversion programs that we have. But if you can't, then there has to be an alternative to keep the public safe.
Okay, I think that, one second, I gotta respond. The area of juvenile crime is probably the most fertile field for intervening and diverting young offenders from becoming career criminals. Incarceration is probably the least appropriate tool for the overwhelming majority of juvenile offenders. If we can intervene or divert a juvenile offender out of the system and get them into a program or a structured setting that enables them to develop better life skills, make better decisions, get out of a bad family arrangement, get away from drug addiction or alcohol problems, that individual is going to have a much higher likelihood of becoming a productive, law-abiding citizen. I'm aware that there have been a series of incidents at Juvenile Hall that is causing a lot of folks great concern. I think we have good, capable people working on those issues, and that's one area that will probably deserve a little investigation and maybe some fine-tuning after this next election.
Okay, good, thank you. We'll go back to this, Mike, I'm sorry.
Mike Tabaki, Middletown. could both candidates please comment on the value of hiring attorneys specializing in environmental law who will be able to prosecute the damages caused by the large-scale commercial growth.
Large scale what?
Commercial grows.
Oh, thank you.
Go ahead, Doc. Who wants to go?
Who's first? Who do you direct the question?
Both
Go.
candidates.
Well, since Don went first last time, Andre, please.
It's my understanding that there are lawyers, prosecutors available on a statewide basis to pursue environmental crime. I've actually worked on a matter with one of those attorneys, contracted out to the Lake County District Attorney's Office. You know, environmental degradation is one of the primary negative outcomes or effects of large-scale commercial marijuana cultivation. Clearly, in spite of the fact that California law provides a safe harbor for genuine medical marijuana patients, the folks that are growing large-scale grows out on federal land or trespassing on private land aren't terribly inclined to observe prudent farming practices. We can't afford to allow those people to damage what is most valuable to Lake County, namely our unspoiled environment, the health of our lake, and we're going to have to continue in spite of the fact that social attitudes are changing towards medical marijuana and the law is evolving in a much more tolerant way. We're still going to have to be vigilant and protect Clear Lake and our watershed from environmental degradation caused by the illicit cannabis industry. I think the same thing can be said about other ag in the county as well. We've got to be very careful that we protect Lake County's primary asset, the lake, and to the extent that property owners on the rim of the lake or other groups are engaging in practices that are detrimental, we have to be very vigilant and, of course, prosecute when behaviors cannot be modified through other forms of motivation.
Yes, currently, excuse me, we have a prosecutor by the name of Matt Carr, who is actually hired by the California District Attorneys Association to prosecute environmental crimes in Lake County. Unfortunately, he has also, I think it's 16 other counties he does the same thing for. So he is an employee of our office, or 1/16 of him. But he actually gets paid by the California District Attorneys Association. And most of that money comes from part of the asset forfeiture. Here about a year and a half, 2 years ago, I went to the Board of Supervisors, specifically with this issue. That I wanted to prosecute environmental crimes, well, all environmental crimes, but especially environmental crimes related to marijuana. And I asked them for a investigator, which would have been a trained investigator into environmental crimes, and an attorney to prosecute those cases. They all thought it was a great idea. Unfortunately, with the budget, it was turned down. We currently are working on several environmental crimes. Some are related to marijuana and the environment. And we have had some classes just recently. I think it was 2 weeks ago. We had Matt Carr coming up, teaching a class to, I believe there was about 40 or 50 law enforcement officers. At this meeting was held in City Hall in Lakeport, an educational, trying to draw a plan how to combat this problem. And it is a very big problem. We're doing the best we can with the resources that we have.
We had over on this side. Any questions over here?
Just on this side.
Yes, sir.
Brian Martin, Lakeport. With criminal justice realignment being implemented 3 years ago, what plans, policies, and practices are you implementing or you plan to implement to deal with the impact that it's had on our criminal justice system and our jail here in the county?
Before they answer that, I've read that criminal justice realignment. And I want to make sure everybody understands what realignment means, because it's a little murky.
Yes.
Can anybody tell us exactly what this criminal justice realignment means in simple terms so we understand?
It's the shifting of the responsibility for incarceration of non-violent, non-serious, and non-sex offenders from the state to the county. It was enacted in response to a Supreme Court decision to reduce the population of our state prisons, because the Supreme Court found that the overcrowding that was occurring at the state amounted to cruel and unusual punishment. We're starting to face a similar problem here in our local county jail, and I want to make sure that we avoid that problem where the federal government doesn't come in and dictate what we do here on a local level and say that we're only allowed to house X amount of offenders in our facilities, and forces us to release people on the streets that maybe shouldn't be.
Maybe if the group would allow me just to ask another part of that question, so that we understand, the state was so overcrowded that instead of them handling the problem, they shifted it to the counties, so the counties have to do their job. Is that basically it?
You know what gravity does on a hill?
Yeah. Okay. All right, thank you very much. Okay, who wants to go first? Andre, you're first.
Listen, if you follow the press, you've certainly heard that there have been some nights recently where our jail has been full to the gills with offenders, people pulled in off the streets. I think it's prudent to make certain that every jail bed in Lake County is reserved for the worst of the worst, so that we don't exceed our capacity and thereby violate the constitutional rights of folks who have to be incarcerated. I commend Sheriff Rivero and his team for working hard on securing some external funding for a new expansion to the jail facility, and I would encourage our next sheriff to do the same thing, and I've told Frank to do it again if he can do it. Any dollar spent on making conditions out at Hill Road more humane and more practical is good for Lake County. We've got to steer offenders away from incarceration who aren't going to benefit from incarceration, and we have to keep serious and violent criminals off the streets. Unfortunately, we're carrying a little weight that the state used to carry, and we're just going to have to be prudent about how we allocate our resources. I think over the long run, certainly within a decade, we're going to have to be talking about a jail expansion or some other similar project, and it would be very prudent, I think, to start talking about it now.
Thank you. Don, would you stand up so the people requesting that they hear better?
Oh,
Would you stand up?
Sorry. One part of the jail population is we're getting people sentenced to what used to be a maximum of 1 year in the county jail. Now they're receiving 10 years. I don't know what the highest one is. I believe it's over 10 years in the county jail. So of the limited beds we have, they're being taken up for a long period of time. What I've tried to do, part of what I've done, is implement a diversion program. So you have the minor misdemeanor cases hopefully go into a diversion so it doesn't take up a jail space. When we can, we will charge and try to do negotiations and pleas, or not do the negotiations and pleas, to ensure that the person receives a sentence or conviction of a crime that will allow that person to go to state prison versus the county jail. One thing I can do, which I refuse to do, and that is do what they call a split sentencing. Now, split sentencing is we won't, the courts can do it, but I will not participate in it. And a split sentencing, first of all, if you get sentenced, say, to 10 years in prison, county jail prison, and you automatically get 5 years off, so you get half time off. On a split sentencing, it can be negotiated. Okay, you'll spend 2 years in the county jail and 3 years on some other type of monitoring program or something. I refuse to do that. If you get sentenced to the 10 years, you do your 5 years. I got no control over the other 5. But I will not participate in split sentencing. If the judges want to impose it, I have no way to control that, but that's just my policy. I can't realistically and morally do that. And it's unfortunate. I think that the Sheriff's Department or the jail is going to be at odds with us, because I think that if a person commits a crime, he needs to go to jail. I will try to get that sentence, whatever that sentence is, just. And I'm not going to worry, I say not worry, but I will not base my decision on the population of the jail. That is something the sheriff is going to have to deal with, probation will have to deal with, in the courts. But my obligation is to seek justice, and that's what I will do.
Okay, any other questions from that side of the room? You first.
Thank you. Kathy Mayer. This is a follow-up to the question I did ask you about the Middletown Ford. And it's my understanding you did not have any police reports when you made that release. So can you explain to me who in law enforcement talked to Craig, Art, or you to give you the details of the case to make you want to make that release?
You have a misunderstanding.
Okay.
Okay. The police reports were given to our office. Craig Woodworth, like I said, was the first one to read the police reports, found out there was a problem. Then Art Groves was the second one to read the police reports and called me the second one. Now, we never will release somebody like that until we have the proof one way or another, especially with these allegations. When I got back to the office later on that afternoon, Art Groves sat down with me and gave me the police report. And that's when I read it. After I got done reading it, I saw there was all kinds of problems with it. Even not only in the issue of whether or not the defendants were guilty, not guilty, whether they could prove it or not prove it, but also the constitutionality of some of the actions of the officers that made the arrest, which would have eliminated almost all, if not all, the evidence, the statements, everything. So we basically have nothing. So yes, I will release somebody immediately on those circumstances.
Do you have any?
No, I don't have a
Yes,
response.
ma'am. Name?
Okay, Joe Ross, you stated in your brochure that you successfully used the criminal grand jury system. I understand we have a civil grand jury system, and I would like you to go into detail about which case it was and how you used it and how Lake County can form a criminal grand jury. Thank you.
First, easy part first, we've used the grand jury that I will make public twice. I'm not saying we haven't before, but sometimes there's a confidentiality, and that's one of the reasons why we use the criminal jury. The two that we used it on was a home invasion case where we did a home invasion, 5 people in Clear Lake Oaks, and later on their flight out of county, they ended up shooting the Clear Lake police officer. The second time criminal grand jury was used is another home invasion, or a home invasion. 4 people did home invasion, shot at the people there, and fled. They were later captured, but during the pursuit of these people, another officer got involved in an accident and ended up in a tragic accident and ended up killing one of the drivers. Those are the 2 that I would reveal right now that
The
was
officer
used.
killed who?
Ma'am,
Officer,
he'll answer the question. This is not a,
I couldn't hear.
that's okay.
Somebody sneezed.
Yeah, it's where the officer got in an accident and killed the driver of the other vehicle.
Oh.
Okay. I can go to parts of your question. Oh, why we don't, the civil grand jury versus the criminal jury. There are 2 ways you can do it. You can have the civil grand jury hear criminal cases. Some counties do that. For instance, Yolo County has 50-50. Sometimes they use a civil grand jury to hear the criminal cases. Sometimes they impanel a criminal grand jury. I've taken the option to always impanel criminal grand juries. Steve Hedstrom, the presiding judge, and I had a discussion how we want to do it. My preference at first was to impanel a criminal grand jury for a 1-year period, and then use them when you can. When cases come up, we use them. Judge Hedstrom, I'm not saying he's wrong and I'm right by any means. I like his idea. Is we will only impanel the criminal grand jury for a short block of time, and we'll do one case right after another. So we either run out of cases, and then the criminal grand jury is done with their service. I plan to use the criminal grand jury more and more as time goes on. I can't get into details what we have in plan for the future, but they will be used.
Andre, you want to speak to that issue?
No.
Okay. Yes, ma'am. Name?
Wanda Harris again, and I wanted to make a comment about my question before. On Lakeland News, you said that there were 16 on the Brady list, and you took 8 of them off. So and you just told me 12 and 6, so I'm just curious. But my question to you is, what compelling new information did you have when you became the district attorney to go back to a 2008 case that had been closed and put Sheriff Rivero on the Brady list, particularly after you won because of him?
Wow.
Your opinion. My opinion. Okay, that's my opinion.
That's fine. I'll try to answer it. And like I said, I haven't reviewed that list in some time. I don't recall seeing that Lake County News. I may have. I don't know. But it's pretty close. Whether Sheriff Rivero was the reason I won, or was I the reason the Sheriff Rivero won, I don't know. I don't care. We're both in office. Totally. And what new information I had? None. The information, when I got in, my chief deputy brought to me information that he had investigated the case against Sheriff Rivero. And at about the same time, a deputy who had terminated service with the sheriff's office, who was involved in the incident, came in and says, hey, Sheriff Rivero lied to this investigation. Craig Woodworth knew this already. I didn't know anything about the shooting. So they brought the case to me, and as a notation on the case by John Hopkins, who did the investigation, he indicated in his report that there were a lot of inconsistencies in Sheriff Rivero's statement. Okay, that's just what he did. When I reviewed it, I immediately saw there were some problems. Pursuant to the policy that I wrote, I gave notice to Sheriff Rivero. I think there are problems. You have the opportunity to be heard. We grant you a meeting with us to explain your situation. And he came in, and based on information he gave me, I conducted a whole new investigation, just given the benefit of the doubt. I wanted to be sure before I make that determination. So my investigators went out and interviewed everybody involved again. We did even a little more in depth about the shooting scene and came to the conclusion that yes, he deserves to be on the Brady list. Tough decision to make, probably the toughest decision I've made since I've been here. But something you gotta know about Brady, I have not only a constitutional obligation to do this, I have a moral obligation. And I think anybody who is a defendant in a case, or if you're on a jury, would you not want to know if the officer has a credibility issue? Whether he has issues of moral turpitude or issues of knowing to lie. If anybody here was accused of it, would you not want to know? I would. If I was sitting on the jury, I would want to know. The law says I have to disclose that. And if I do, I'm going to do it. I don't care who it is. And that's what we did. And to be clear, you said something similar to the fact that he was cleared in his investigation. True. He was cleared of criminal activity. I cleared him of criminal activity. But the lies that were done was not criminal, but they were still lies. So I did it then, I'll do it now, and I'll stand by my decision.
Andre, go ahead, and then I'm going to make a statement on this line.
This is a perfect opportunity for me to talk to you about District Attorney Donald Anderson and his attitude towards lies. At last week's debate, a little bit of truth snuck out of Don Anderson's mouth when I asked him about his inconsistent statements about his bar registration. I heard Mr. Anderson say that he forgot to send in his bar registration card reporting his compliance to the state bar. What Mr. Anderson said 3 years earlier to the voters at a debate and to one of his deputy DAs on a radio program was that he had mailed items into the bar and was subjected to an audit.
Excuse me. The question was not about Don Anderson. It was about the Brady list.
Yes.
And let's stay on the question.
And I am staying on the question because Mr. Anderson's response says, Johns Hopkins noted inconsistencies in
The
2008.
answer is not the question. The question was about
I
the grade
object
list.
to your interference. Do
I was-
something about it.
Okay.
Why do you
Be
put me off
quiet.
for? Why do
Be
you put
quiet.
me off for? Why do you do that, sir?
Because you're interfering with the debate.
That's right. That's right. So please stay with the question. She had a question. I want you to answer the
I'm
question.
answering the question. Now, Mr. Anderson's response at last week's debate had a material inconsistency with the two stories he told on the eve of his election in 2010. Mr. Anderson has a credibility problem. And the only thing that exceeds his credibility problem is the hypocrisy of imposing a Brady determination on a political opponent. When a district attorney is more concerned about winning than telling the truth to the voters that pay his salary, we are surely in a sorry state of affairs. Mr. Anderson planted the seeds for this discussion 4 years ago when he told falsehoods to the voters at a debate and when he elaborated on his falsehoods on a radio program. I've waited 4 years to bring this issue to the attention of the public in Lake County, and I think you all have a right to know about that before you decide whether or not you want to re-elect Mr. Anderson. Mr. Anderson cannot be put on the Brady list. Mr. Anderson is a prosecutor with prosecutorial immunity. The only sanction Mr. Anderson will ever face for having lied to the voters in 2010 is for those same voters to throw him out of office this time.
Okay. Now, we're not going to get into specific cases because this is what happens. Okay? Guy back there gets mad at me and flips me off, and that's not right. You know, I'm just trying to get the questions that people out there are asking and get the answers from the candidates. That's why we're here. So please, don't ask about specific cases because it's not fair to Mr. Ross. He's not involved in the cases maybe. So let's try to be fair with both candidates. So ask General. No, you're not going to get another one. Yes, ma'am.
Courtney Newman from Middletown. This is to Andre Ross. I was just reading your pamphlet and it states that Mr. Anderson has made decisions, important public decisions upon factors unrelated to pertinent facts and governing law. What exactly are you meaning in that? Is that just against his bar, what you've been talking about,
No.
or is it actually?
I think the first example that I saw with my own eyes was the Justin Lazard matter, in which Mr. Anderson gave a sweetheart deal to a gentleman who was arrested with his penis sticking out of his pants in Library Park in Lakeport. And Mr. Anderson explained in a recent radio interview that he was relying largely on the wisdom of his good friend Paul Swanson, who's a very capable attorney in Lake County, who was also Mr. Lazard's defense lawyer. I was in the court that day with Lakeport Chief of Police Brad Rasmussen to watch Mr. Lazard receive his sentencing. I watched Mr. Anderson sit, the prosecutor who handled that file for over a year and a half, sit down in a chair and enter into an arrangement that allowed Mr. Lazard to escape the registration as a sex offender. That wasn't based on pertinent law, it wasn't based on the facts of the case, it was based on the fact that Mr. Anderson's campaign associate and friend was representing a defendant who, by the way, fled the jurisdiction and avoided Lake County law enforcement for an extended period of time. I find that galling, and I think the voters should find it galling as well.
Thank you.
I guess, with your permission, I can address the Lazard case. It sounds like that's what the answer was.
It sounds like
That was my answer.
Okay. So let's talk about Jason Lazard. Okay, been referred to as a pedophile, which he is not. It doesn't mean the qualification of pedophile. What he's charged with is indecent exposure. To prove indecent exposure, you have to have two things. One, the exposure. No doubt he exposed himself in public in a city park. Second thing is you have to have the mental state of mind to do this with the intent of sexually gratifying yourself or the person watching you. Now, Jason Lazard had a total mental breakdown at this time, very unusual to him. Remember, the issue is sexual gratification. He did have his penis out. It was not erect, it was flaccid, and he was holding it. He is looking off into the space. You get 3 police officers surrounding him. And what does he do? Nothing. He still holding it in a flaccid state and doesn't put it back in. That's the first clue. Then the police officers take him to the ground, put him in the back of the patrol car, and what happens, what he says? He says, "Please tase me again. I got to get the demons out of me." Okay. This happened all before my time at the office. And there was a deal made, and I'm not saying it's a bad deal. Basically, he gets 1 year summer probation, no more jail time, but he has to register as a sex offender. Okay. When I got in office and I reviewed the case, and I did it with my sexual crimes prosecutor, we had problems with the case. We would have difficulty, if not impossibility, to prove the sexual intent of this person based on what that was, and the fact he had 2 psychologists, his 2 psychologists coming up to testify, there was no sexual intent. We had nobody to testify that there was. And also, which someone fails to mention, the victim, the girl who observed this, her father says that child will not testify. Can't blame him as a father. I don't know if I want my little daughter saying that too, but we were going to have problems with the case. My evaluation is the probability we would have lost that case and we would have gone free. What I did, I formulated a deal with Paul Swanson, who is a friend and I respect him very much. Based on all this information, I feel he will not get 1 year probation, he will get 3 years probation. And as one of the terms of probation, he has to continue his counseling with his psychologist in New York. And I'll mention why New York is very important. He will have to continue with counseling, and every quarter, that counselor, who's a licensed psychologist, has to send a report to me and tell me about his progress. If he doesn't, he's violated probation, and good chance we'll prosecute. And there were some other conditions too, but those are the main conditions I changed. Okay, but he would not have to register as a sex offender. One of the reasons why, because he's a resident of New York. What Mr. Ross fails to tell you, if you're not a resident in the state of California and you're convicted in order to register as a sex offender, you do not have to do that. He would never have had to register in California unless he moved from New York to California in his permanent residency here. He could go back to New York, and he's not violating any California law. So he did not have to register. I believe, and I believe right now today, that my decision was better for public safety. And this gentleman, Mr. Lassard, has completed his probation just a few months ago, successfully completed. There's been no other problems. I've seen no reports of any misbehavior on his part. I understand that he's doing very well. That's what I did with Lassard, and under these circumstances, I would do it again. Thank you.
Thank you very much. We have time for one more question. Marlene?
Yes, Marlene Elder, Middletown resident. I was wondering if either one of you know if there's any grant money, either at the state level or at the federal level, that might be available or that you could try to get to help us get more than 1/17 of an environmental attorney to help us? 16.
I'm not in the office, so I don't know, but I conclude from the fact that it hasn't happened yet since Mr. Anderson made his proposal to the Board of Soups several years ago, that the money is hard to find. Maybe Mr. Anderson has some good news for us on that, but I would certainly think that finding more resources to protect Clear Lake is a top priority.
Got no good news. We've tried, and we're still trying to find money for additional grants, but to clear up one thing, it's not a grant, it's final prosecutor is on. California District Attorneys Association has a a budget, whereas I think there, right now, there's 2 environmental prosecutors in the state. Ourselves and 15 other counties have 1, Matt Carr. But he's not really paid by a grant, he's just paid by the state.
But is there more money to maybe for all of us to share 2 instead of 1? Or is there grant money that could be, oh, sorry. Sorry.
I wish the EDA would give us a lot more money, but they're very limited in their funding also. If we can find money.
Thank you, Don. We're going to close out, since Mr. Andre opened, we're going to let Don close first, and we'll give him 3 or 4 minutes to make his closing statements, and then Mr. Ross will make his closing statements.
Do we have the opportunity to ask one last question?
Questions are over. Mr. Anderson?
Unfortunately, I didn't get much of a chance to address the issue with the state bar. I guess that would be my closing. Andre, you said early on, winning versus the truth. That's not what you're doing. You're not telling the people here the entire truth about this incident. Like I said at the last meeting, and there's nothing that you have brought to the people. This came up 4 years ago, and I was the one that brought it up 4 years ago during the last campaign. So it's hard for you to take credit for discovering this because you did not. Okay, what happened is really simple. I was negligent. I messed up and I didn't get my bar card in. By the time I got it in, I was too late. I sent it in. I got in contact with the bar, they got in contact with me. This is 4 years ago, I forget which way it went. And they said I had enough units, but I was 2 units short in ethics. And by the time I got this notification from them, I had appeared in, Andre says 8 days, maybe so. I was thinking 5, 6, 7, but maybe it was 8 days. And I made appearances, I was doing a trial, and I made some law and motion appearances on several cases. I can't remember exactly how many, but there were several. But what's important to know, the time I was making these appearances, I did not know my license, and it was not suspended. I went over this last time, there's a difference between suspension and being inactive. That my license was inactive, never been suspended. My license was inactive. As soon as I learned about it, within 1 day I took all the classes online, faxed them over to the state bar. They said, you're fine. And they, ironically, they sent me notice about a week later that I was reinstated. Then the very next day, I got the notice that my license had become inactive. So that was actually, it was about 2 weeks later, is when I got the first official notification I was inactive. So, to be clear, very clear, license is not suspended, it's inactive. And also, I had never practiced law with the knowledge that my license was inactive. Thank you.
Now, in order to be clear and accurate, it's unlawful to practice law when your license is inactive. The distinction that Mr. Anderson draws between suspension and being inactive is a sham. Mr. Anderson stated to the voters in September of 2010 that he had been audited. That's also a sham. Mr. Anderson allowed his license to expire despite the fact that the state bar requires compliance in February of 2010 and sends a certified mail notice and sends an email notice to those lawyers who haven't complied and does a number of other steps to try to help errant lawyers get their ducks in order. Mr. Anderson let his license expire. He did a trial in Lakeport for 2 days. He did a half a dozen appearances at other matters, and then after the Labor Day weekend, he got his ducks lined up. That's all fine. I don't have a problem with a lawyer who's only negligent. I have an issue with a lawyer who lies about his negligence in order to win public office. If Mr. Anderson had stood up at that debate and said to everybody present, my license was inactive, I was negligent, and I'm very sorry, and I think I might have violated the law, will you still please elect me DA? He didn't do that. He told a story, and it's an incorrect story. And then he elaborated on that story 3 weeks later. And if there's anything ironic about this, is that his opponent in that election apologized to Mr. Anderson at the start of that September debate for challenging Mr. Anderson on the veracity and the validity of a teaching credential. Mr. Rhodes, fell on his sword at the beginning of the debate for having challenged Mr. Anderson's ethics and his honesty about that. And at the end of the debate, Mr. Anderson told a story. If the voters look at my website, you can see the minute orders from all the appearances Don made. If you look at my website, you can see all the deadlines all of us lawyers have to observe. You can also look at the Business and Professions Code sections that pertain to lawyers who practice when their license is inactive, and you can read for your own in black and white. It's a misdemeanor with a 6-month penalty and a $1,000 fine, and I'll leave it to Ed Borg to figure out how many counts Mr. Anderson committed between September 1st and September 8th. Now, do you want a district attorney who's willing to lie to you? I don't think so. The most fundamental requirement of a district attorney is to tell the truth at all times, the good, the bad, and the ugly. And Mr. Anderson failed that test in September and October of 2010. And for the last 4 years, you've gotten to see what Mr. Anderson's program for Lake County looks like. If you like the last 4 years, vote for Mr. Anderson. If you want to bring Lake County kicking and screaming into the 21st century and elect a DA who won't lie to you, vote for me. Thank you very much.
That concludes. We're going to ask the candidates if they would to stick around for a few minutes. If you have questions outside of that, if they want to answer them, it's fine. For Matt, for the town hall, I want to notify you that next month, Corby Olson and the financial director of the Middletown Unified School District will be here to discuss the funds, the use of the funds on the bond issue, and the plans for the new grammar school. And we'll have a set of plans here we can look at, and we can look over the budgets and find out where the money's been spent, and if we like the way they've been spending it. So next month will be a good meeting, be an opportunity for you to question Corby and the school system on how they're using your money. I want to apologize to the gentleman at the back for getting irritated because he flipped me off. I do apologize. Oh, he did it again. So, very good. Thank you for coming. All right, that concludes the meeting, and again, we'll try to keep people, keep the candidates here if you have questions. The meeting is adjourned. Wait, now, when you get outside,
high school to the Martin Street to Painting. It's about a mile.
It's been like that forever. So,
yeah, well, and I drive it maybe 3 or 4 times a day.
I know you do.
They need $500,000.